Hello, everyone, and welcome to the Truth Reveal podcast, where we host conversations that relate in order to reveal and to reconcile truth. Today, we're going to have a good podcast and a good conversation for you. We have a couple of new faces, as you guys can see. And so at this time, I personally would like to introduce our guest today, Ms. Connie Whitener, Esquire, who will be lending us her legal expertise to discuss this topic that we're going to be talking about today. We're going to have it in our show notes because Connie is available for speaking engagements. She has a law degree from none other than North Carolina Central University. Right. And she currently is practicing as a corporate attorney. So thank you so much, Connie, for being a part of this show and episode.
Yes, welcome.
Absolutely. And I'm going to let my co-host, Ms. Holly, introduce our other special guest.
Well, yes, the other smiling face that you guys see is none other than a great friend of ours, Shanita Rogers. Woo!
Whoop, whoop.
Okay, we get some applause. we are so excited to have her. She is going to be an extension of the podcast. She's going to be another guest co-host that we're bringing in. As we talked about in a previous episode, we lost April, so we're going to be bringing Shanita in. She's going to be bringing with her expertise. She's an author. She's a speaker. She's a conference host. She has a degree in communications, actually, and I believe you used to work for the news as well, right?
I did. I was for a short while.
Yeah, so she ain't new to this. She true to this. So we have someone that's going to be joining us that is very knowledgeable, and we are so grateful to have her and all that she's going to bring to the podcast. So welcome, Shanita.
Thank you. Glad to be a part.
Yes.
Thank you. So now that we've gotten all of the pleasantries out of the way, let's deep dive into the topic of discussion for today. So today we're going to be talking about affirmative action. This is a hot topic right now, as there have been some recent developments in our nation regarding this very hot topic. And so we want to deep dive into affirmative action, what it is, where it come from, who is going to impact, who's benefited from it, what does the reversal that took place with the Supreme Court on June 5th, what does that mean for minorities, for us as a nation? And we're going to utilize everyone here to just kind of give their opinion and share. And we hope you guys enjoyed this episode. So just to start out, giving us a little bit of facts and just doing some research for myself about the topic, because as far as I can remember, or as long as I can remember, I've always known about affirmative action, but I never really knew where it began, how it started, just the inner workings of it, the initial concept. So I did what most people do when they research nowadays. I went to Google and said, what is affirmative action and how did it start? And so just to give you guys just a quick overview, because it was a pretty extensive find when I did look up Google. So definition first, just so we can make sure that we're all on the same page. Affirmative action is defined as a set of procedures designed to eliminate unlawful discrimination among applicants, remedy the results of such prior discrimination, and prevent such discrimination in the future. So back in 1961, President John F. Kennedy issued an executive order 10925. And within that order, it included a provision that government contractors take affirmative action to ensure that applicants are employed and that they're treated fairly, and that's without race, creed, color, or national origin. So that was the inception, 1961. Fast forward a couple of years, September 24th, 1965, President Lyndon Johnson also issues another executive order 11246, which kind of supports what President Kennedy had put in place, but basically it was prohibiting employment discrimination based on race, color, religion, and national origin by those organizations that were actually receiving federal contracts and subcontracts. And then 2 years later, same President Lyndon Johnson, came back in 1967, and he amended the initial order to include sex on the list of attributes of things that you couldn't also discriminate against. So that's kind of like where we get the affirmative action initiation, which I don't want to jump ahead of myself, but the fact that we had to have something put in place already denotes something. So we're moving forward. And I think there was a case, it was Regents University versus California, and it was dealing with affirmative action again. And so with this case, I'm just going to read what I typed out. It upheld affirmative action, allowing race to be one of several factors in college admission policy. However, with this case, Regents versus the University of California, the court ruled that specific racial quotas, such as the 16 out of 100 seats set aside for minority students by the University of California Davis School of Medicine, was impermissible. So apparently there was a case that took place with this Regents of University of California, and I think it was versus BAKKE, and they had a certain amount of seats set aside for minorities. So you had 16 seats that were set aside for minorities only in order to get into this medical school, which, 16 out of 100, that's not a good percentage. But it was ruled that this was impermissible. So we started seeing affirmative action taking place. This was around 1995 when this case took place between Regents and the University of California. And so there were additional executive orders that were put in place, SP1 and SP2, and just to be kind of brief with those definitions. So SP1 said that the University of California shall not use race, religion, sex, color, ethnicity, or national origin as criteria for admission to the university or to any program of study. So actually, the University of California does not uphold affirmative action and haven't since 97. And then I'm backtracking. In 1996, SP2 pretty much states the same thing, that the school wouldn't use race, religion, sex, color, ethnicity, or national origin. This is more so pertaining to employment as criteria in employment and contracting practices. So that was very interesting for me, because I grew up in a bubble, and I will admit that I was thinking that everyone was utilizing these principles and policies of affirmative action. But when I started doing the research for this particular topic and episode, I realized that actually at the University of California, they've not practiced it since 96 or 97. So I thought that was interesting as it pertains to how I view affirmative action as opposed to what's been taking place in an environment that does not have affirmative action in place.
Yes, just to interject right there, when I was kind of reading up, it said that 9 states already had it.
Yes.
Yeah, had already abolished it or said we're not going to do affirmative action. So.
And this is 9 states prior. Thank you for that interjection. This is 9 states prior that have already abolished affirmative action, if abolishment is the right word, before June 5th of this year. So there were already states within our country that do not practice. So just the transition in who benefits from affirmative action, because I was always under the impression that it was something that was put in place to kind of level the playing field for minorities, specifically for Black people, because of the obvious racial injustice. But again, when doing a little bit of research, and I just want to read to you guys and have you chime in. I'm just going to read what I wrote out. It says that the Labor Department in 1995 found that since the 1960s, affirmative action had helped 5 million members of minority groups and 6 million women move up in the workplace. But technically, the research is saying that those who really benefited most from affirmative action was white women.
Pretty much.
So again, I was like, this topic is getting very convoluted a little bit.
And it's, just to kind of interject right there, like
yeah,
when
absolutely.
I was reading an article, it was saying once again, we kind of get scapegoated as being, because if you go back to welfare, they mentioned that in one of the articles, they thinking we the kings and queens of welfare when we're not the ones who utilize it the most, but we get scapegoated into being the ones just like with affirmative action. So I just wanted to point that out. But
yeah, I think that's a very valid point.
Yeah.
So it is true that it was supposed to be for African Americans, and that was what the agreement was in the beginning. But when the additional executive order came out, including sex as one of the protected classes, the shift came. So the carve out was supposed to be for us. And that got turned within 2 years.
Yeah. Wow. 65 to 67.
I was going to say from college campuses to the workplace, white women have a dominant presence in those arenas. And there's a growing number of white women who are becoming more educated. And so they are reaping the benefits or have reaped the benefit of affirmative action strongly in our history. Most people just don't know that.
And that's in business, government contracts, education, and employment.
And that is so true, because when I was doing my research, that was one of the things that they stated. They stated that white women are escalating up the corporate ladder. Like they are literally making their presence known in all sectors.
And to your point, I think Holly said we would get, or either it was Holly or Latricia said that we would get scapegoated and painted with the affirmative action brush, that you're coming in and taking our jobs without merit. You're coming in and taking our place in schools without merit. You only got into this position because of affirmative action. But we weren't reaping those heavy benefits that way
at all.
And you don't hear someone saying the missive to white women who did reap the most benefits. You will rarely hear someone say you only ended up in this position because of affirmative action.
Right.
You don't hear that
at all.
And now they will say other things that are inappropriate. However, that's one of the ones they don't say, even though they have reaped the greatest benefit from affirmative action.
We have seen like an increase with Black women becoming more educated, starting more businesses, and I won't say having a stronger presence in the boardroom, but we're there sometimes, just not as much. But it's almost like I don't want to say we've been sold a story, but media has a large influence in what we believe. So we think that Black women have a very strong presence. And that's not to knock that we do have a presence, but it's not as strong as the white women. And we've been thinking all along that, okay, well, this is just for us. It's not just for us. There are other groups who benefit from it. And I'm glad that we are now taking it upon ourselves to become more educated about what our laws are, and actually learn what's really happening, because if we don't know the information, then we really have been bamboozled and
Good point. And run amok. I think that's a good point that you're bringing out, Shanita, because it's a good segue into something else that I found out as it pertains to June 5th. And Connie, definitely by all means jump in here. So when I was doing the research, because I was like, okay, affirmative action has been in place since 61. And I know that there's always been that talk of getting rid of it. But I kind of was interested in what was the catalyst for this new shift that actually brought about it being removed. And so, of course, we've heard about Harvard and UNC, University of North Carolina. And so I would like at this time, if you could, Connie, just to speak a little bit about that. But before you do, one of the things that I did find when I was just kind of researching the why behind this recent change back in June, it says that the court majority made it clear that it agreed with the Student for Fair Admissions, which sued Harvard and UNC. Among other things, that the schools discriminated against Asian American students who had SAT and grade scores higher than any other racial group, including whites, and who made up at Harvard, for instance, 29% of the entering class year. Just to keep reading, it asserted that, and this is the student for fair, how do you pronounce? Student for Fair Admissions went on to say that a number should have been higher than that, though Asians are just 7.2% of the US population. And so that was kind of the thing that got this ball rolling. I don't want to say got the ball rolling, because I think the ball has always been kind of slowly rolling, but this is, I see your face. It's coming. Give me a second. It was the thing that, like, it was a lot of conversation that obviously produced some results. So Esquire, talk to us.
So let's talk about this case. So some years ago, there was another case called Grutter, and you probably read about Grutter, that upheld the university's right to consider race as part of their admissions process and policy. There have been challenges to Grutter over time, and back then, I think Sandra Day O'Connor was the majority writer for that decision. And at that time, she said, eventually, this will go away. So eventually, in their mind, there would no longer be a need to have this affirmative process and procedure to make sure that discrimination was being thwarted in some way through these admissions policies. And she upheld the right for the universities to include race in their decisioning. Well, in comes this conservative group, and they found this student group with the model minority to be the face of this case that we have before us now, that happened on June 5th. So they have this group of students who made the accusation that they were not being granted entry into these Ivy League schools and into UNC in particular, which happens to be my alma mater, because they were giving spaces to undeserving minority students, being Black students. Let's not say minority. They were giving undeserving African American students positions in these universities, when these model minority students have higher SAT scores. Well, if all of us know that SAT scores is not the only consideration made when you're doing your college application. However, this is what they focused on because this is where you can come in and say, here is a hard and fast number where you can see that we're higher here. Our test scores are higher, so therefore that means I should have this spot and you should not. Mm-hmm. The funny thing is that in the decision handed down by the overwhelming majority conservative court now, because you have to think, let me stop and say voting matters. Wow. Because we are in a position where you're seeing a lot of these affirmative type protections, privacy protections, rights to certain protected class of people start to whittle away. They're going away because you had 4 years where a conservative president, well, I wouldn't call him conservative. I'm not going to go off on that tangent, but a president came in, was able to put in 3 new justices, which swung the court to a 6-3 majority. And these are, like, I went to law school and we had this group called the Federalist Society, and they were like ultra conservative, read the Constitution without considering modern changes and things that the Constitution didn't consider. Like, there's a group who sees the Constitution as a living, breathing document. So you adapt.
It ain't the word.
The Constitution says. You adapt what the Constitution says to the times that you're in, right? Because some things weren't contemplated at the time when the Constitution was written and ratified. And then there are those who are strict constructionists. That means if it doesn't say it in the black and white of the Constitution, then it is unconstitutional. So that's the far right leaning Federalist Society group. So you keep those in mind. So now I'm going to pull us back to this case. So you have this model minority group who is the face of the case, but the real push behind it is this conservative group who wants to do away with affirmative action in total. So what they said was that they were using race as a negative in their admissions policy, meaning, well, if you're not a minority in this particular group, then your race counts against you, and therefore that's discrimination. So this is how they fed it into the court. This is what the court decided. This was the part of the ruling that whereas Harvard and UNC were doing a noble effort in making sure that they're inclusive and they had good intentions, that they were also using race as a negative, even though both schools denied it, and they, put forth their evidence, and people wrote in. We have this process called amicus curiae briefs that get sent in. So it's basically friends of the court. They'll send in a brief like, we've researched this. You had corporations writing in saying this is going to cause a problem if you make this decision in this way, because we believe in diversity, equity, and inclusion, and you're whittling away at that by doing this. I want to say there were professional groups like doctors, because now if you have less opportunity for minority doctors, you're putting minority patients at risk, because we already know, you can research this, that there's health disparity and inequity for minorities, and that is plagued by the fact that you will rarely see a face like yours treating you, and therefore there are some inherent biases that come in to your treatment. So you have all these groups saying, don't do this, because the net result will be very bad for the corporations economically, will be very bad for medical professions, so on and so forth. So nevertheless, the court said, we're doing it. And so they ruled that race cannot be considered in admissions say like in point-based systems, like you get a point for this, you get a point for that, or in just a consideration strictly off of race. But what he said was, on an individual basis, this is the majority opinion, on an individual basis, you can consider a person's race if it motivated them, or if they somehow they not overcame discrimination, but it impacted them in some way that encouraged them to seek out higher education or something like that. But it can't be specific to race. It has to be race mixed in with this one unique person's life experience. That's very different than the system that was set up at Harvard and UNC and some other universities, where you would look at a person's race or even socioeconomic background. Like this helped students who are in poor rural areas as well. Like you look, all these types of programs help people who are underrepresented. So you think about that and you take that away, and people don't see the far-reaching impact this will have on more than just, okay, these Black folks don't deserve to be here. And I'm saying this, and people may disagree and say, well, it wasn't just about Black people. Yes, it was. Black people are in these spots and they don't have the merit to be here. We do. And so now what they don't realize is you're taking away that, but here's the funny part. They left in for like the Naval Academy.
Yes.
Naval Academy can consider race in the same way that UNC and Harvard did. Why is that?
Why is that?
Why the military schools can consider race for the same reason that Harvard and UNC were considering race, but now these public and this private university can't. And they chose a public and a private university on purpose. Because private university, private funds for the most part. So they wanted both so they could hit both ends. So they didn't want it to be where we're going to tackle this just in public universities with this lawsuit. We're going to make sure we tackle private universities too. So it's covering both of our bases. So now you can't just say, well, it only applies to public or it only applies to private. It applies to both.
I feel like I need to see law after that.
And I wanted to just touch on that because I was reading an article in The Guardian, and it was just basically talking about how, again, how race was scapegoated and how there are other forms of affirmative action. There's, donor admissions, there's legacy admissions, there are athletic scholarships. Those two are affirmative action. And it went on to talk about how that there was a study done, and they found that nearly half of all white students at Harvard were either athletes, had alumni parents, had donor parents, or were children of Harvard employees. Only 57% of Harvard's white students had gotten in on their merit. So for Black students to be singled out, almost kind of pitting the Asian students against the Black students, in essence, for us to be, singled out as the ones not in on our merit and not considering that their white counterparts, some of them were also were in that predicament. And my thing is, how do you know for sure people are not in on their merit? Like if you get into the university and you excel, how in the world can you say that somebody is not in on their merit unless did they pull their grades, or they didn't say they ain't do none of that. They just assumed.
They looked at like statistics on like minority test scores, like those types of things. But let me give you a personal experience with something like this being painted with this brush. I'm not going to say any names. I'm going to say we went to high school with this young man.
And I know who it is, but go ahead.
Yes, you do, because I have told this story a number of times. I'm going to just keep it real brief. So I was academically gifted growing up, since I was probably tapped before I even started school with a very high IQ. I was in the same classes, AP, honors, doing a whole lot of other things in school where I was excelling, and it was very well noted. It wasn't a secret. We shared the same classes. However, we were both up for this really big scholarship. And I won. I, along with another student in our school, won, white male, and me. Well, this other gentleman who was in our class, when I got called to the office to let me know, be at this banquet or not, he happened to be in the area. He was like, well, you know, you only got it because you're Black.
Whoa.
I said, you know what? Yes, I did. I was like, because you know what that means? I'm highly intelligent, more than capable, and clearly did better than you. And so,
Right.
yeah, that's exactly what happened. But I said that to say this. They don't know. This is just another iteration of racism coming through a different voice. To me, let me be clear, to me, because whether this person was they can look at people in Harvard, and whether that Black person was the valedictorian of their high school, had my niece just graduated from high school with a 5.127 GPA and taking AP courses, doing extremely well. But let's say she had chosen to go to an Ivy League versus going to another school that she's chosen to go to. So when she's there, they're not seeing her 5.127 GPA. It's just another Black person here taking somebody else's spot who is more deserving.
Crazy.
It's really taking opportunities for our Black community is what it's doing. There was an article that I was reading about UCLA. California is always in something. Love lost to California, but that's just the truth. Even in HR world. But there's a gentleman by the name of, I think his name is Corey Matthews. He was the VP or is the VP of JP Morgan Chase. He went to UCLA. At the time that he was applying, it was like around 2003, 2006. There were 96 freshmen at UCLA that were Black. But there was a process in which the whole affirmative action thing was under review. During that time, there were almost 5,000 Black students who were able to get in as freshmen. And what I see happening is, if you're removing that doormat for us, which is, it's a welcome mat, is what it is, we're going to see a decrease in who's able to have access, because not everyone has a family member that's alumni. Not everybody has a family member that is a veteran. Veterans are included too. So not everybody has that access point. So we're really just withholding from people who are underrepresented. We're going back in time is what's taking place. We're going back. Not that we've ever arrived fully, but we are taking steps back when we should be moving forward.
Because it kind of insinuates that discrimination no longer exists. I mean, it's almost like the insinuation, well, this is no longer an issue for us, so we're just gonna move this to the side. Yeah, come on, sir. and then for Clarence Thomas to be, bless his heart.
That's the Southern thing that people say when they don't want to say something else.
He admitted that he benefited from affirmative action. Yeah. So now that you've arrived, well, I'm just going to take it away for everybody else. Like,
and that's the thing. It's like, you know, he was in a time where the quota system still existed. That has been gone, I want to say, since the 70s, and at least in employment. And I think the thing is, like, it's a double-edged sword, because it's like, are you saying that the only reason we're able to enter these institutions is because affirmative action exists? That for then lends to someone saying, well, that means you don't have the merit. But the truth is, The affirmative action was there to protect people who did have the merit and not have discrimination prevent them, even though they had the merit. And that's what people leave out often. It's like, no, you're not coming in on a meritorious basis. Like, they're giving you leeway to not be able to meet the bar, and then you get to come in when you don't meet the bar. That is not the case. It is like, you're qualified. They have continuously discriminated against you, even though you are qualified. They have put more barriers in front of you, even though you meet the qualifications. What affirmative action is going to do is take those barriers away. And because in the media and in certain political structures, it's been painted as though, no, affirmative action is a handout. Affirmative action is there to give people spaces that they don't deserve. They don't deserve this. Why do they get an opportunity to go to these places and be in these spaces? When the truth is, for so many years, which is why this exists as part of the civil rights movement. And that's the crazy thing. Like, we fought, bled, and died for it. In 2 years, it was twisted to give the right to someone else who did not necessarily on a grand scale do so. And then we become the poster child for unmeritorious access that we still didn't really have. Like, in my profession, we only make up, I want to say, less than 5% of the legal profession.
Wow.
That's crazy.
Yeah.
And you know, and you tell people that you know, this is the thing that I feel like we hear in our community is like, you have to work 10 times harder to get half as much, you know, and I hate that. And I'm like, because you're going to tell someone to burn themselves out to prove themselves to somebody who don't care if you're working 10 times harder or not. You could be top of your game, A1 in the class. Certain people will not want you there. And I'm not saying all people, but there are certain among us who look at you as though you will never deserve. I don't care if you are 2 years old or you're a Mensa. Like, they don't want you in that place. You're taking from them something that they own, and you don't have a right to it. And that's where a lot of this comes from. It's not that, oh, Asian Americans were underrepresented. They were overrepresented in these spaces. At Harvard. Now at UNC, like, I looked the other day when I went to college, we made up, I want to say, like, my class, we were coming in one of the largest class of minority students back in the day. And now it has dwindled and like flipped. And I looked the other day at the statistics, I was like, wow, like, it's dropping precipitously. But I saw like the Asian population growing precipitously. Like, it's not completely flipped, but I see the flip. But even that's going to change. That's the crazy part, because now you're no longer allowed to consider race as part of the determination. That's going to impact Asian students.
Yeah.
Like, you didn't think this
and
through.
They use them to make their case, but then.
And I think Holly said it, and you said it as well, Connie. Not to harp on it, but we can't not harp on it because it's very evident that this is still race-based. There was a study that was done. I was reading this article, and I know you guys have all heard about this. They took 5,000 resumes, exact same resume, and they sent them out. Various companies, literally exact same resume. The only thing that they did different on the resume was the names. Some names had more Black sounds, some were not. Same exact resume, and the Black sounding names did not get the jobs, did not get the callbacks. And it was the same exact resume. So what was the motivator?